During a pretrial deposition in a medical malpractice case, how do I get a doctor to actually admit that he did something wrong? You want to know the answer? Come join me for a walk through downtown Manhattan as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. It's not as simple as turning to the doctor and say, "Hey doctor, isn't it true that you screwed up when treating my client?" No, that's not how it works. That's not how any of it works. Okay, so how does it work? Well, it would be great if I could go into this pretrial question and answer session known as a deposition and simply confront the doctor and say, "Hey doctor, isn't it true that you screwed up and as a result of that, my client suffered harm and injury?" The reality is the doctor is never going to admit that. I don't care what anybody tells you, it is certainly not easy, and never will the doctor go ahead and actually admit that he did something wrong. So what can I possibly do to try and get this doctor to actually admit in his own words that he violated the basic standards of medical care, causing you harm and injury? I'll tell you how. One of the ways we do that is when I get to question the doctor in a medical malpractice case. This is a deposition. Lawyers also call it an examination before trial. The doctor's attorney is present, I am present, and there's a court stenographer there to record all of the questions I ask and all the answers that the doctor gives. During the course of this deposition, I have an opportunity not just to ask the doctor about what he did and why, but I have an opportunity to go ahead and ask the doctor opinion questions, hypothetical questions. I want to know from the doctor if he has a clear, good understanding of the medicine, if he knows the anatomy. And importantly, I want to establish what is the standard of care for the particular circumstance that my client was seeing him for. That is a critical component of starting the process to get the doctor to actually admit that he may have violated the basic standards of medical care. So let's use this hypothetical example of a patient who has a breast lump, who goes to her doctor making a complaint of a lump in her breast. Now, one of the goals I want to establish is that the doctor knows what to do when a patient comes in with such a complaint. So I'll ask a series of questions. Doctor, would you agree that when a patient has a lump in her breast and now comes to your office for the very first time, it is critically important that the patient identify the complaint about why she's in your office in her intake form, correct? Yes. And this way it alerts you and the office staff to her initial reason for why she's coming in. Would you agree? Yes. And now, when you actually see her and now start to talk to her, it's critically important that you learn from her what her complaint is and what brought her to your office. Would you agree? Yes. And by talking to her, you are now trying to establish a history and trying to get details about what brought her to you. Would you agree? Yes. And in fact, that's the standard of care, correct? Yes. He has to say that. So now, doctor, when a patient comes in making a complaint of a lump in their breast, it is critically important that you ask the patient details about that complaint. Would you agree? Yes. And doctor, would you agree that you then have to ask a series of follow-up questions to determine how long this lump has been there, whether it has grown over a period of time, when she first noticed it, whether it's palpable when she's laying down as well as standing up, and things along that nature. Would you agree with that? Again, he has to say yes. Would you also agree that after taking a detailed, thorough history, it is critically important, and in fact it's the standard of care, that you go ahead and perform a physical examination on the patient? Yes. And now, as part of your physical examination, you will palpate the patient's breast where she complained of the lump in her breast, correct? Yes. And you'll do that with her in sitting up, correct? Yes. And also good medical practice requires that you do this physical examination of that breast while she's laying down. Would you agree with that? Again, he has to agree with that. And in addition, doctor, you would also agree that you are required to also examine the opposite breast, known as the contralateral breast. Would you agree with that? Again, he has to say yes. And there's a specific reason why you want to examine the opposite breast in which the patient has a complaint of a lump, correct? Yes, it's because you want to compare and contrast one breast with the other. Is that true? And again, he has to say yes. So what am I doing with these series of questions? What I'm doing is establishing that the doctor has a clear understanding of what the standard of care was at the time that my client, his patient, came in to see him. Now, there are always factual disputes in these types of cases, but I'm not up to that yet. So what I'm doing is laying the groundwork. Now, why do I do that? Because I want to establish what the standard of care was for a patient who came into his office with a complaint of a lump in her breast. Now, why do I do that? I do that because later on, when I actually go through this patient's records, I want to be able to establish what he did. And then I'm going to compare and contrast what he did with what the standard of care was. And importantly, I'm going to ask him opinion questions such as, Doctor, would you agree that if you failed to do a physical examination on a patient who made a complaint of a lump in her breast, that would be a departure from the standard of care, correct? Again, he has to agree with that. Would you also agree that failing to examine the patient's opposite breast would also be a departure from the standard of care? Again, he's got to agree. Would you agree that failing to examine the patient in both a sitting position and a laying down position would also be a departure from the standard of care? And again, he has to agree with that. So what am I establishing? I'm establishing that now these are the standards of care for this type of patient. And now when we go through and establish exactly what he did, I'm now going to ask him hypothetical questions. Now you should know, because the doctor is a defendant in the case, because he's a named party to the lawsuit, the law in New York considers him to be a medical expert, which means I can ask him medical expert opinion questions, and I can do it in the form of a hypothetical. And why do I do it in the form of a hypothetical? Because the doctor's going to disagree with our assertion of the facts. In this hypothetical example, we are arguing that the patient made a complaint and that the doctor failed to do certain things during this particular office visit. Doctor, do you have an opinion with a reasonable degree of medical certainty that if this patient came to your office with a complaint of a lump in her right breast, that good medical practice required that you actually examine that breast? Yes, I would. Now, would you agree that if you failed to go ahead and examine the patient's breast after she complained of a lump in her breast, that would be a departure from the standard of care, correct? Yes. And that would be a clear departure from the standard of care. Would you agree? Yes. And by establishing what the standard of care was, and now establishing that if certain facts are found to be true, then the doctor has to admit, in his own words, that failing to do certain things represented a departure from the standard of care. And that is how I get a doctor to admit that he screwed up. Now, remember, he's not coming right out and saying, yes, I screwed up. He's saying, listen, that didn't happen, but if it did happen, yes, I would agree that would be a departure from the standard of care. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in the state of New York. You know, I recognize you're likely watching this video because you wanted to see the beautiful scenery. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit, but haven't done so because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.